And the next case is State of Ohio versus Christopher Herman. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. Would you like to reserve time?
Yes, Your Honor. With the court's permission, I would like to reserve 5 minutes.
Very well. The arguments are being recorded. Please keep your voices up and stay behind the podium. Please do not use the names of victims or minors or children.
Yes, ma'am.
You can refer to those folks by initials or by general terms. The judges have read your briefs, and we are ready to proceed when you are.
Yes, ma'am. Ma'am, if it pleases the court, Attorney App.No on behalf of Mr. Herman. I did not know this was Second Amendment Day in the court. However, in keeping with that theme, we have Mr. Herman, who's been charged with having weapons while under disability as well. The problem is that he also, this is a weird case in that it is a divergence and convergence of both the Second and the Sixth Amendments, of which I cannot find similar cases of would carry those two unique amendments. In the state's case, they argue that the Second and Third Amendments there are waived. I obviously would argue that they are not. But if the court was to accept that, then I believe that the court would have to reverse on the First Amendment error, which is the ineffective assistance of counsel. Counsel in this case recognized, as federal courts have been doing lately, and the Ohio Supreme Court started to do in State versus Philpotts, that the analysis that we've been using for the past, let's call it 100 years roughly, of Second Amendment law was flawed, and has been pushing back and focusing Second Amendment rights not on as a collective group, but instead on an individual basis. And when counsel recognized that, the problem with his presentation to the court, as well as his analysis of the case, was severely flawed in that he's filing the wrong motions. He's allowing his client to plead what he believes is a no contest, then an Alford plea, then a guilty plea. He asks the court to appoint an appellate counsel because he admits in his sentencing hearing that he is ineffective. What is a reasonable defendant to do in that circumstances? The whole purpose behind why we have attorneys is not to generate revenue for the Bar Association, but is instead to provide solid legal advice and guidance to individuals who aren't blessed with the level of legal education and training that we are. The whole purpose of having an attorney, and that's why I cited back to our founding fathers when they were crafting the Sixth Amendment, was what was the purpose? What were they going for? They wanted people to be able to stand up in court, whether they had 2 nickels or $2 billion, and to have somebody with them who was an effective advocate, someone who maybe didn't get the desired result, but at least had a consistent theory. And that's not what we had in this case. We had counsel filing an initial sentencing memorandum, which was really a motion to dismiss, failing to attach the necessary documentation to support his argument, and his argument, as I'm going to go to in a second, does have some merit and should be reviewed. Then going to a sentencing proceeding, well, I'm sorry, let's step back, going to a plea prior to filing that motion, where he indicates that it's going to be an Alford plea, that it's going to be a no contest, it's going to be, and the client is standing there and just going along with it. The client is not going to know what the difference between and what rights are waived with an Alford plea versus a no contest plea versus a guilty plea.
Is there anything in the record that illustrates that the performance of the attorney affected the voluntariness of the plea?
Well, the question is whether or not the plea was made intelligently and knowingly.
So that the judge is supposed to explain what each of those pleas mean or what the plea he's pleading to means.
And the rights that were being waived.
So is there anything in the record that indicates that the plea wasn't voluntary or knowingly?
I think the fact that appellate counsel was requested due to ineffectiveness at the sentencing shows a backwards trend towards that. But the fact that there's no, that essentially, when you read the transcript, counsel's just sitting there saying, is spitting things out. which is, oh, well, if that's not gonna work, then we're gonna go to this. If that's not gonna work, we're gonna go to this. But there's no explanation to the client as to what rights are actually being waived. And so that's where we go back to the issue is, there's no explanation to the client and to the defendant, the person who's actually going to jail.
So you're saying the record shows that it's confusing, could be confusing to the
I would actually say,
defendant?
I would actually say with all due respect, that it was beyond confusing. And having been in those pleas, and I know Your Honor's been in those kind of pleas too, the client is relying on what the attorney's saying. And has a right to do that. And has a right to understand what the difference in the pleas were. And perhaps Judge Croce should have gone back and re-explained it. Perhaps Judge Croce should have pulled the attorney off the case right there on the spot. I wasn't there, obviously. But in order for somebody to make an informed decision to enter a plea of guilty versus a no contest plea, this is not a question of is it guilty or not guilty. This is a question of guilty, no contest, not guilty. What was the client's, what was going through the transcript that shows a completely chaotic situation from a legal standpoint? But then when counsel later admits that he's ineffective, to be honest, I believe Judge Croce should have shut the whole case down at that point and allowed new counsel to come in and advise the client, this is what your rights are, this is what's been filed so far. So that the client, the person who's actually sitting in prison right now, understood what the rights were he was giving up with the various plea options. And so that's what my concern is with this case, is that when you're reading the transcript, it does not, and then looking at the docket in combination, counsel did not have a reasoned or logical approach to this case. That transfers through the sentencing, where during sentencing, counsel says, I know you're going to send him to prison, but I still want you to give him probation. But I know you're going to send him to prison. That's not a consistent argument. At that point, if the judge has already indicated, let's say in chambers, she's going to send him to prison, then your argument is, I would ask you, Your Honor, to keep the prison sentence to a minimum. He got maxed out on this particular term. The only thing he did not get was a consecutive sentence with the CCB. But you don't argue for probation if the judge is saying he's going to give prison and then sit there and flip-flop between the two. Or you argue for a CBCF, or you argue for something else. But it's a consistency throughout the course of the case that there's just no consistent argument. And then you bring into the Second Amendment argument, keeping with today's theme, of there is a legitimate question right now as to what is going to be deemed to be constitutional in the light of Daniels, which I believe the Supreme Court is going to be deciding, or they're going to be having a conference on it January 5th, in the light of Romali, which was just argued the other day, and in the light of Bruin, which is the case out of New York. There is an evolving view of what the Second Amendment encompasses and what protections it gives. Counsel recognized that, filed a motion that I believe was flawed, at least in caption, but at least gave the general concept of a motion to dismiss. It should have been filed pre-plea, or there should have been, which goes to the ineffectiveness, a motion to withdraw the plea that would have been written and filed on the basis of, I want to call it newly discovered evidence, but newly discovered legal research. When we go to the Second Amendment, we are looking at, and I'm looking at, I believe it was Justice Thomas who wrote the Bruin decision, where there is a retraction from the historical view of a global perspective when it comes to the Second Amendment, which is what is better for society, to what is being recognized now, which is more of an individual right as to what the Second Amendment really means. And I think that Bruin, and I cited at page 21 of my brief, where Justice Thomas goes back and looks at what was the historical purpose of the Second Amendment. And in cases like this, where the underlying conviction is based on a narcotics conviction, was that one of the ideas back at the time of the founding as to when somebody could have their firearms rights restricted, which at the time of the founding, at least based on the research I provided in my brief, and the research that's out there, the major factors that were looked at when somebody could have their Second Amendment rights stripped or their firearm rights stripped was really an act of sedition. It was not narcotics abuse or alcohol abuse. It was not many of the other things that are in the current Ohio's current equivalent of their disability statute, which then brings us to the third assignment of error. In the third assignment of error, I'm looking strictly at Ohio's Constitution.
Attorney Van Ho, can I ask you a question, please?
Yes, ma'am.
The state says that trial counsel raised constitutional arguments, but they aren't the same ones that you're making. Do you think that's true on the record?
I don't think they were as eloquently raised as I've raised them. I think that he laid the foundation for them when he filed his initial sentencing brief. And so I would agree that he did not raise the state constitutional argument, which I believe would then be subject to a plain error analysis.
Counsel, I do want to let you know you're into your rebuttal time now.
I at least want to answer Judge Lancer's case. I would argue that he laid the foundation. I believe that I've expanded on the argument on it, so I would argue that it's not completely waived. The problem is obviously it was a guilty plea as opposed to, which goes back to the first assignment of error, it was a guilty plea versus a no contest. And I believe had counsel insisted on a no contest plea under State versus Daniels, I think it would have been abuse of discretion for Judge Croce not to have accepted that. Unless the court has any other questions, I would reserve the right balance of my time.
Okay. You have 4 minutes to have rebuttal.
Good morning. May it please the court, my name is Rick Raley. I'm appearing today on behalf of the Summit County Prosecutor Sarah Doug Walsh and the appellee of the state of Ohio. I think this court should affirm the defendant's conviction and sentence. I do want to address, just jumping off from Judge Lancer's question about the issue that was raised below. The trial counsel actually raised something about the constitutionality of subdivision A2 of the Had Weapons Under Disability statute. The defendant was convicted under subsection A3. So that's why I think that it has been waived for that purposes. And I would go to our first assignment of error where I talk about a little bit about the effective assistance of counsel. But I do just want to talk broadly about this evolving nature of the law around the Second Amendment. Defense counsel just said it's a weird case, there's no similar cases. I think that that screams for why jurisprudentially it's a good idea to say that these arguments are waived because there's not been a factual development of this record to address new constitutional law. It would need the benefit of full briefing below, full consideration of the issues, not the way that the record reflects now. And I think that also means for the assignment of error 1, it would also be best to avoid a broad declaration that there is a brewing issue potentially with this case. Okay. So for that reason, I think and I'll start with the first assignment of error, we need contemporaneous evidence that this defendant would not have pled guilty if he received the advice that Mr. Van Ho has said on appeal he should have received. Number one, I don't know if that would have necessarily been the appropriate advice. This is a statute that has existed in the state of Ohio for decades. It's been enforced without question for decades. There's not a single case in the state of Ohio that has held it to be unconstitutional. There's not a federal case that has held that a prohibition involving those convicted of felony drug offenses can have firearms. It would be a brand new, novel interpretation to go forward with that. It's hard to tell a client that you should go forward and hang your hat on that. So I don't think it's unreasonable strategy not to raise this particular constitutional attack that has been referenced to you on appeal. And then, again, we go to the prejudice that prong of the Strickland test. Padilla involved a case where the lawyer misadvised about deportation consequences. Lafler involved misadvice about the facts of the case and whether you can prove intent when you shoot someone below the waist. Those kinds of factors that led to ineffective claims there do not exist here. Again, this is a brand new, novel interpretation of the Second Amendment that would not have been proper advice to have given someone. And I would point out 3 separate times during this plea colloquy, and it is not relying on the trial lawyer. It's the trial judge's obligation to make sure that this defendant knows what he's waiving, the consequences of his plea, and there is a full Rule 11 plea colloquy reflected in the record. So that is where I think this court should go. If we do want to go to the merits of these Second Amendment issues, I will address them now. And I'll start out with, there is going to be more litigation here in the years to come about the Bruin case. We're seeing it in federal courts, we're going to see it here. I want to start with the foundational view of Bruin and what it did and what it didn't do. Bruin involves New York's very unique, very extreme concealed, not even concealed carry, any public carry. It's such an extreme law that the Showtime series Billions has an entire multi-episode story about how difficult it is to get a concealed carry under that law. Under that particular law, the Supreme Court says, no, that goes far, too far. A provision that bars violent offenders, felony drug offenders from having a gun, completely different. And I looked, if we want to look at the history of this country, I mean, there are provisions going back to our founding, barring drunkards, people of poor virtue from having firearms. I do think it is interesting, I will point out that Virginia had a law in the 1600s that barred all drunkards from using guns, except at funerals and weddings. But as long as other times that it was not appropriate against the colony of Virginia. I also point out Heller, which is our seminal case from the U.S. Supreme Court. Justice Scalia, he has highlighted various long-standing provisions that are presumptively lawful. One of them is possession of firearms by felons. This is such a broad expansion from what we have seen from the courts, would not be appropriate to adopt it here in the procedural history of this case. I'd also point out that Daniel's decision, the Rahimi decision that are cited from the Fifth Circuit, neither of those cases involved convictions. They both involved federal prohibitions of a drug user and someone who was the subject of a restraining order. The Rahimi decision is currently before the United States Supreme Court. They had arguments recently, and I think we'll be intrigued to see what they said on that issue. And also, I would just point out, also on the new federalism argument, the third assignment of error, the courts have routinely recognized that the Ohio Constitution provision and the federal provision are very similar. They have not been treated differently, and there must be a clear reason for why we would treat them differently. And actually, when I looked at this text of those provisions, the Second Amendment says, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. By comparison, our Constitution says the people have the right to bear arms for their defense and security. Similar ideas, and in fact, if you look at it, I think that the Ohio Constitution has a more limited provision for that right, so it might even have a lower floor for what the rights are. But there is no reason for this court to adopt the new federalism arguments contained in the third assignment of error. And unless there are questions, I'd ask you to refer.
I have a question. You argue that the timing of the motion isn't errant or deficient?
Pardon?
You argue that the timing of a constitutional argument isn't deficient. But then you're saying if you raise it after the plea, then you're limited to the voluntariness of the plea. So, which is it?
I'm not saying that, so, my point was being that if he files a motion in the trial court about the correct statute challenging the constitutionality, then the issue would have been preserved. In fact, if nothing had been raised below about constitutionality of the statute, that could still be raised on appeal. It's not like a suppression decision where if you fail to challenge it, if you do a guilty plea at that point, suppression is waived. It's forfeited, not waived.
But if you would have made the wrong constitutional arguments, you could argue ineffective assistance of counsel if you did it pre-trial.
So that's where I would get into that maybe that is not something that should be done. Clearly, you should challenge the correct statute.
Or pre-plea, I mean.
Right. But even if you did challenge the correct statute, as Mr. Van Ho said in appeal, I don't think that would have been a reasonable strategy based on lack of case law for it. And also, there's no prejudice. And there are other questions I had just asked you for. Thank you, judges.
Thank you, Tom.
Your Honor, I actually would ask you to do exactly what the Ohio Supreme Court did with Bill Potts and remand the case back to the Court of Common Pleas. The basis for that is that I believe we have shown ineffective assistance of counsel, but I disagree with my colleague as far as what Daniels and O'Malley are showing. And we are showing that there's a split in the federal circuits at this point. The state courts, as the Ohio Supreme Court acknowledged in its decision in Philpotts, had not had a chance to analyze Romali, and so that they're ordering it remanded, and it's since been remanded, I believe it's to Judge Saffold in Coffee County at this point. But we are seeing an evolution going back to Justice Thomas's argument that in order to justify regulation, government may not simply persist that its regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation.
Counsel, then are you suggesting that having weapons under disability can only arise when one is involved with sedition?
I'm arguing that you have to look back at what was considered to be a disqualifying offense at the time of the founding. And when we're looking at Ohio's Constitution, I believe you would have to look at what the language was specifically in the Constitution itself, which unlike other state constitutions, which was referenced in the Texas law review article, does not contain a disqualifying offense. So for example, other state constitutions have specific provisions within them that allow for the state to remove a person's ability to have a firearm based upon felonies and other things. Ohio's Constitution does not have that in either the 1803 version or the 1851 version. With regards to the Second Amendment, the court is looking back at what would have been a prohibition at the time of the founding. At the time of the founding, sedition was the number one that I found, but I believe there may be a few other exceptions. However, the possession of narcotics or drunkenness would not have been one of them, according to the historical records that have been researched and go back to the Second Amendment. In this case, the prohibition is he was previously convicted of an act that involved illegal narcotics, which I think actually does mirror Daniels, because Daniels, the issue was that he was a drug abuser. And in Daniels, the possession itself to abuse would have been a violation of federal and state law. In this case, what I'm arguing is that we do have to look backwards at what would have been the disqualifying offenses as they existed at the time of the Second Amendment's enactment. And that's where I'm going back to. I think Romali may be looking at the issue of what is the present danger factor, but that's not a present issue in this case. There's no indication that there was any dangerousness by the fact that he was previously convicted of possession of a controlled substance. So I think that we have to look historically at what, this is what the Supreme Court's looking at. And I think they're going to look at Daniels, and I think they're going to look at it through a similar light, which is would having been addicted to or use of an illegal narcotic, would that have been a disqualifying offense in 1791? And the answer is no. We know several of our founding fathers were Herman. We knew several of our founding fathers were drunks. That's historical. So I'm not saying, what I am saying is that that's what we have to look back at. What were the type of offenses at the time, and what were those disqualifiers at the time? So I'm not saying it is just sedition, although I think that arguably should be applied. But we're not arguing that case at this point. What we're looking at is within the context of somebody who's been previously convicted of a narcotics offense.
Thank you.
Thank you.
Thank you very much, both of you, for your arguments. Are there any other questions? The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it's released, and the opinions will